Hi guys, we'll be starting with the concept of nuisance as of now in the tort law. Again, Winfield की definition हमारे सामने आ रही है. Nuisance means what? An unlawful interference with a person's use of enjoyment of land or some right over it or something which is connected to it. Nuisance is generally continuing in nature. It may be temporary but should not be momentary. Very important to note that. Negligence and nuisance. Nuisance may be caused by negligence, but it is not a prerequisite. It is enough to show that some harm was caused to the enjoyment of property due to an act by the defendant. Very easy to understand, right? ये difference है. Public nuisance क्या होता है, अब हमें ये समझना पड़ेगा पहले. It is un it is an unreasonable interference with the right of whom? General public. यार किसी राह चलते आदमी को अगर तुम उसकी नॉर्मल वे ऑफ लाइफ में इंटरफेयर कर रहे हो तो वो इंटरफेरेंस को हम न्यूजेंस का नाम देंगे. इट इज अ क्राइम अंडर सेक्शन 270 ऑफ भारतीय न्याय संहिता. देयर इज जनरली नो रिकोर्स अगेंस्ट द पब्लिक न्यूजेंस इन लॉ ऑफ टॉर्ट except where one can demonstrate a private right of action in case of a there is a special injury in respect to general public. Second, it is directly arising from the same cause जो इंसान ने किया था. Thirdly, it is very much substantial in nature. रामराज वर्सेस बाबूलाल का एक केस है. द डिफेंडेंट put up a brick grinding machine next to plaintiff's clinic. The dust from the machine entered the clinic and caused physical inconvenience to the plaintiff and to his business. Thus, special damage to the plaintiff was given over and above public, which was eventually proved. तो मतलब न्यूजेंस प्रूव हो गई थी. Then, private nuisance क्या होता है हमें ये समझना पड़ेगा. The following conditions need to be proved. First, unreasonable interference प्रूव होनी चाहिए. Every interference is not a nuisance. Every person must put up with some noise, some vibration, some smells, or inconvenience so that other members of the society can enjoy their own rights which is given to them. With the use of enjoyment of land could be in the form of what? Physical presence, branches of a tree overhanging into neighbors' premises, or gases, vibrations, or sounds. Right? Then there is the case of Radhe Shyam versus Guru Prasad. They were running a flour mill in a residential area, and it was eventually known as what? Unreasonable interference, and thus it was known as a nuisance. The sound and vibration caused by the mill was an unreasonable interference in the enjoyment of the property of the residents. That was held. Unreasonable interference का prospect हमें ध्यान रखना है. Next, Ball versus Ray. Defendant converted a part of his house into a stable for horses. Converted जो कन्वर्ट कर दिया था एक पार्ट को स्टेबल में. The constant noises throughout the night caused inconvenience to the neighbors and was held to be what? Nuisance. Remember that. Another case of Noble versus Harrison. A branch of tree overhanging a public road was not a nuisance, and neither was the fall of the branch onto the road. However, a projection onto private land would be held as what? Nuisance. Remember that. It should be substantial in nature, as de minimis non curate lex का कॉन्सेप्ट यहाँ आ जाता है. मैंने आपको पहले पढ़ाया भी था. कहाँ पढ़ाया था बताइएगा. It is generally continuing in nature. It may be temporary, but should not be what? Transitory. Remember that. Remedies क्या क्या है न्यूजेंस की? Actual damage need to be proved, plus special and substantial injury should be established. Defenses क्या क्या है न्यूजेंस के? First, prescription, statutory authority, slight harm. Right to perform an act which would otherwise be nuisance may be acquired by prescription. Statutory authority, act done under statutory authority or permitted by it. फॉर एग्जाम्पल जो एमसीडी वाले ड्रिलिंग का काम करते हैं, एमसीडी फॉर एग्जाम्पल मैं लिख देता हूँ. ठीक है, अगर वो परमिटेड है तो वो अलाउड होगा. स्लाइट हार्म, देखिए अनरीजनेबली इंटरफेरेंस जो है वो सिर्फ स्लाइट हार्म में अगर रिजल्ट कर रही है तो ये माना जाएगा. नेक्स्ट, ट्रेसपास और न्यूजेंस का फर्क क्या होता है हम ये देखते हैं. Trespass is physical interference with the plaintiff's possession of the land. Nuisance is interference directly through other tangible and intangible modes, also vis a vis noise, smell, etc. Trespass is a tort, and nuisance can also be consequential tort of trespass. Planting a tree on others' land is trespass. A tree planted on your land goes to your neighbor. Land is nuisance. ठीक है, ये बहुत इंपॉर्टेंट डिफरेंस है, ध्यान रखना. It is interference with the possession of land. It is interference with the use and enjoyment of land. ये इंपॉर्टेंट डिफरेंसेस है, पेपर में आ सकता है इस पे क्वेश्चन. आइडियली ये बोलते हैं ना, हॉट क्वेश्चन है, हॉट टॉपिक्स होते हैं इन रिस्पेक्ट टू न्यूजेंस. ट्रेसपास इज एक्शनेबल पर से फॉर एक्शन अगेंस्ट न्यूजेंस. स्पेशल डैमेज, जो मैंने आपको बताया ना, स्पेशल डैमेज का प्रोस्पेक्ट, वो प्रूव होना बहुत जरूरी है. नेक्स्ट, व्हाट इज पब्लिक न्यूजेंस? क्राइम अंडर सेक्शन 268 ऑफ आईपीसी पब्लिक न्यूजेंस है. ये अब ये चेंज हो गया है, बताइएगा कहाँ हुआ है. पढ़ा चुका हूं मैं ऑलरेडी इस क्लास में. सिविल रेमेडी प्रोवाइडेड अंडर सीपीसी. प्राइवेट न्यूजेंस इज सिविल रॉन्ग. रेमेडी अवेलेबल है टॉर्ट में थ्रू स्पेसिफिक रिलीफ एक्ट एंड द सिविल प्रोसीजर कोड. इंटरफेरेंस विद द राइट ऑफ पब्लिक इन जनरल. इंटरफेरेंस विद द प्राइवेट राइट ऑफ एन इंडिविजुअल यहाँ दिया हुआ है. It cannot be legalized by prescription. It can be legalized by prescription over a long period of time. It is actionable only when special damages are proved. It is actionable per se. So this is all for nuisance. Very small, very concise. I hope you like the video. See you in the next class. Bye.